CodeX group meeting. I'm Roland Vogel, and this is going to be our last session of 2020, which we're excited to see, as everyone else, 2021. Anyways, yeah, we have two great presentations for you all today. We have Joaquin Santuba, who's the head of design. This is legal design. He's a research associate also with the Hasso-Plattner Institute. And he will be telling us about his work with the Chilean Supreme Court on legal design and the digital transformation of the court. And then we have Stephanie Santana, who's a practice development lead at Legal Force and a co-founder of Latin America. And she will talk about the legal tech environment, both in Japan and Latin America. So she's has some unique insights into both regions, and we're excited for her to share those with us. And before I turn it over to our speakers, I wanted to see if anyone had any updates for the group, any requests for the group. Okay, so Lance is sharing in the text. All right, his recent paper on AI and law has been recognized by the Oxford Business Law. So congratulations, that's wonderful. And folks, yeah, if you have any updates or requests for the group, then yeah, please unmute yourself and share, or just drop it in the chat. All right, so with that, I think I will just turn it over to Joaquin. Joaquin, are you there?
Hi, Roland. Yes, I'm here.
Hey, good to see you. All right.
Yeah, good to see you. Can you hear me properly?
We can hear you perfectly, yes.
I think I'm sort of disappeared through my, I know the background also works well. Okay, let me share my screen. And then get started. Let me also activate the share computer sound. It's activated. Good.
We see, yeah, we see your slides.
Yeah, can you see my slide?
Yes, perfect. All right,
great.
Over to you. And you have great. So if you could leave, so we have two presentations today, and we have until 2:30. And so if you could just, keep your comments to like maybe 10 to 15 minutes and leave about the same amount of time for discussion, that would be great.
Perfect.
All right. Thank you.
Thank you. Good evening here. I'm from Germany, so here it's already dark outside. But yeah, good day to everyone, different part of the world. Thank you, Roland. Thank you, Susan, for having me here today. I will present my current work in a combination of 3 places that I'm right now. So I'm, as Roland mentioned already, I'm doing research at the Hasso-Plattner Institute here in Potsdam, Germany. I'm head of design and co-founder of This is Legal Design, which is a legal design consultancy working mostly for the German market, but as well we have worked with other European customers as well. And I'm currently a research fellow at the Humboldt Institute for Internet and Society. My research goes around digital transformation of legal services, in particular of justice. And today, I'm going to talk about synthetic justice. Synthetic justice, I refer to this new concept, so to say, which is justice that is being created or is being performed by digital means. And by digital means, I'm referring more specifically to artificial intelligence in general, but what machine learning and deep learning can do today. So we will be exploring a little bit of the future, but also from the point of view of today. So what artificial intelligence can do today for justice. And we need to take a first caveat here that we see justice as a performance. So justice is not a theoretical abstract ideal, but is a practice, it's a performance. It's made of behaviors, of gestures, of rituals. And this performance, we can analyze it, we can quantify it. And at the same time, we can also generate and create new realities because of this performativity that justice has on it. I will talk about the two of them today, and I will start with the analytic part. Okay, so justice as performance. What do we mean with analytic part? What are we looking at? So we're doing semi-automated video analysis. So we're using computer vision technology to analyze publicly available videos of what is happening inside a courtroom, be it online, as you can see here, for example. This is the YouTube channel of the Chilean judiciary system. And they usually every day upload several online hearings or hearings that are recorded in the courtroom. So we look here at different behaviors. We have an agreement with the Supreme Court, so we are allowed to analyze all these several hours of video recording of how justice is being performed. And particularly interesting these days that most hearings are conducted online. So we have plenty access to video. But closer to you, maybe, for those who are in the United States, there's also a very interesting opportunity from the Cameras in Court program, which is a program run by the US court and has been running for several years. Different court allowed to record their sessions. And I'm going to use this case to exemplify, to show you what are we doing and what kind of analysis are we doing. What we're looking for are performative patterns. As I said before, performative patterns are behaviors that make justice, that create justice, that perform what justice is. This is our approach, and I will show you how we do it. So what is what we're doing? This is a video from a courtroom in Northern District of California. It's available here at this URL address. And what we can do here, for instance, is to analyze the facial expressions of the different stakeholders in this hearing. So we can look at the judge, for example, and from his facial expression, we can infer different features. For example, what kind of emotions are driving this session. We can also analyze the behaviors, the gestures, the body postures, the pose. So we can also understand what kind of gestures constitute, create, make these court hearings in the courtroom. We use that by using computer vision. We use two open source software. One is OpenSpace to do the facial analysis, and also we use OpenPose to do the skeleton analysis, to analyze motion. So what do we have? What's the output that we get from this? Millions and millions of data points. What I'm showing you here is big data analytics of micro interactions that happen in court. This plot that I created for this presentation is only one feature of several features of 1 minute of video. So imagine how much data do we have of this micro interaction. So we are generating tons of data. And here more closely, we can look at one type of data. So for instance, here I plotted 5 columns out of 715 in total. And here at the top, we have action unit, facial action unit number 6 and facial action unit number 12 that account for positive emotion as studied in psychology. So here we can see how emotions are distributed in this 1 minute video only. And then here at the bottom, A1, 4, and 15 account for negative emotions. So we can see how these emotions are distributed. And the colors represent different stakeholders. So the judge and the two lawyers, and there was one face also that was recognized. So with such a big amount of data, with all this big data that we're generating, we then can move into generative mode. What can we do with this data? And here we take inspiration from science fiction, the movie Blade Runner. And please pay attention to this short clip because that will serve to build the second part.
They say you're the best memory maker there is.
Well, then they're kind. I love birthday parties.
You work for Wallace.
Subcontract. I'm one of his suppliers. He offered to buy me out, but I take my...
Okay, so what she's doing, she's creating memories. She's creating memories for bioengineered humans that are called replicants in the movie, but because they were bioengineered, they don't have this identity. So she needs to bring this memory, create this memory to give them this identity. So let's see how she says.
It feels authentic, and if you have authentic memories, you'll have real human responses. Wouldn't you agree?
If you have authentic memories, you have real human responses. And why do we take inspiration from this quote particularly? Because in a world where artificial intelligence and machine learning is already being used to automate certain decision making in court, in justice, we need to make sure that once we start automating more, we have authentic experiences so we can have real human responses from citizens. So justice needs to be authentic, even though justice may have certain degree of automation. Okay, so this is our starting point here when we are generating this. How can we create real human responses by having authentic justice? So what if we look at pop culture justice? And many of you are familiar with this icon here, Judge Judy. There are thousands of hours of video recording of this woman. Her expressions, her way of conducting justice is familiar, is common to many people, especially in the US. And you can find several cases for different countries. So every country has its own Judge Judy. For example, in Latin America, that would be Caso Cerrado, and the jueza would be Jueza Polo. Just to show you that every culture has this entertainment justice. And this is not something absolutely new. In a recent paper published at the Stanford Technology Law Review, the authors mentioned that to counteract the alienating effect of automated decision-making in justice, we can look at, for example, entertainment programs that kind of people relate to and make people engage with justice. And that happened already in our system. So most of the population, the closest experience that they have to justice is through television, Judge Judy. So that creates this feeling of authenticity. And even as you see here, she has been 20 years on air, hitting every day top rating. So it's inscribed in the culture. So how do we do it? We explore these futures, and we, same as we do with the real court, we can analyze and we can extract data from Judge Judy's videos. So we can extract emotion, what is happening in this courtroom. And then we extract that motion and we can train a model, as you see here, this one. And this is already possible, right? This is video synthesis. So we do video synthesis, and we then can use several examples that we can make them behave like Judge Judy would behave, right? So this is the same technology that is being used to create a deepfakes video. That's why we have a deepfakes for good here. So how can we create the same video synthesis technology that is being used for deepfakes for good, for social good? So this is the fake videos, so to say, that are being created. So we could do the same using Judge Judy as our input model, as our input, data input. The same could be done with facial expressions. So we have now these judges that are being generated, these videos that are being synthesized, that also have facial expression, that have emotions, that can transmit emotion. Same as before, here we can use Judge Judy's videos as input videos, and then we can put any kind of example of any person that you want to be your judge to perform justice for you. So none of these videos were real, those here, but they are generated artificially. Here is the reference to the libraries that can be used to do the synthesis today. So how does the model work? So this is the generative model. This is adapted from this few-shot bit-to-bit library. So here we have pose, faces, and place data that we input it in the model, and we can provide any example to generate these judges, to synthesis these judges. This is not science fiction anymore. This can be done today. And then we can start thinking of different scenarios. So what if I want to be judged, maybe not by Judge Judy, but by anyone else, by Morgan Freeman, for example? Or you could say, I want to be judged by my parents. So we can also discuss different scenarios. You can think of a divorce case. You can think of criminal justice. And here I want to touch upon a very important point. That is what digital technologies enable us. We're talking about personalized justice. That is a justice that feels personal, is done to serve me, but at the same time has this universal component, which is this universal performance. So remember before I said that identity is not created isolated, but is this identity in relation to others, in relation to the society. So it has these two aspects, personalized, customized for my own experience, but at the same time rely on this common universal ways of doing justice, mode of doing justice, that in our case is represented by how Judge Judy does it. And to summarize, we have presented synthetic justice. And the question that we're trying to answer here, we're speculating. This is speculative design. But how can artificial intelligent justice can also create authentic experiences to trigger real human responses from citizens and from people? That is the core of who the justice system should serve at the end of the day. And with this thought, I would like to thank you for your attention. And yes, I'm open for questions and comment. Thank you.
Great. Thank you. This is very interesting. So can you unshare your slides, please?
Yes.
So there you are. Okay, I can see you. So, okay, folks, do you have any questions?
Yes, I have a question.
Yes.
This is
Go
this is my
ahead.
first time to talk on Zoom. You can actually hear me.
Yes, of course.
Okay, cool.
Go ahead.
In a meeting like this, I should say. But Paul Ekman said there are about 25,000 words in the facial vocabulary. Your work is closely related to Ekman's work. Ekman was pre-AI, but he studied faces for 25 years or so. And so many of these like stick figures you are laying over facial features, many correspond to words in emotional vocabulary. Have you ascribed any emotional vocabulary words to the expressions on your judge's face, for example?
Joaquin, we can't hear you. You're on mute.
Yeah, sorry, and I could not hear very well the question. Could someone rephrase the question, or could you please repeat the question?
Sure. There was a bit of a preface on the question. I'm not sure how much you caught. I was referencing Paul Ekman's work.
Mm-hmm, exactly, yeah.
He was a pioneer in facial expressions. And
Yes.
he ascribed a vocabulary to facial expressions. He had about 25,000 words of facial vocabulary, as I recall. And so, of course, these little stick figures that lay over the faces in facial extraction, these can be correlated to these words in the facial vocabulary. And I was wondering if you had ascribed any facial vocabulary words to the expressions that you were analyzing.
Yes, thank you, Thomas, for your question. Yes, Paul Ekman and his coding system for facial action units is at the basis of one of these software analysis. So we can extract specific facial action units that are identified in the video. And from there, we can infer certain emotional state or certain emotions. I personally don't use the words approach, but we use the coding system also from Paul Ekman. And we try to link it directly to emotions. At a large scale, I have conducted research using OpenFace, the software that I use to analyze facial expression, and also action units. In the case of courts, we're not there yet. So that will have to wait a little bit.
Mm-hmm. Cool. So,
can I ask something?
Yeah, go ahead.
My name is Jana. Why call it justice, since actually a big feature of your justice system is missing, which is the content of the actual what happens in the court is not just facial and poses and places. Basically, justice is served if the transcript of, so you're not taking into consideration any content, any transcript of words, of what's being said, of the conversations. So why not have these features?
Thank you. That's a very, very important question. And we believe that that's already been taken care of somehow. So that's why we want to create a counter point of view to say justice is not just about decision making. It's not just about the spoken word or the written word.
But the combination.
Some people are working there too. Huh? Yep.
No, go ahead, please. Go ahead.
Yeah. So some people are working there too. What we want to look at is this other side. But of course, the spoken word content is a primary objective of justice, definitely. However, we believe, or we start from the point that justice is also an embodied and embedded experience. It's a phenomenon, right? It's a phenomenon. You could call it the phenomenology of justice, if you wish. That's what is our concern here.
Yeah, but I mean, okay, but from an AI point of view, combining all these features, in a sense, with text, with content, is not so straightforward. So it would be very interesting to see how you combine it. The other issue that I have with all these poses, faces, places, it's very cultural. So all these, what happens in a certain country or in, or even nationality sometimes, is very cultural. So how do you take care of the culture differences? And the other thing, I don't think it's authentic if you are basing it on TV shows, because these people maybe, I mean, I'm not familiar with the show, but these are actors, right? Why call it authentic? They're not authentic. Sorry, I mean, the work is very interesting. Don't misunderstand me, but I'm just making some points.
Yes, and those are totally valid point. We believe that this is authentic because not everyone gets the chance to participate in a jury, for example, which is also a way to get closer to the justice system. But many people in the world, the only way that they touch or they sort of experience some glimpse of justice is through these TV shows. And in the public sort of what is called idea, in the ideal of justice, they don't represent a real judge in the court, but they represent this sort of pop icon, which is, in the case of the US, is Judge Judy. In the case of Latin America, is Ana Maria Polo, for example, which is a famous TV judge. So that's how you also can account for different cultural differences. So you would train the model not with just Judy for the world, but you would train the model with every TV show judge for every country.
So Joaquin, let's say this research kind of ultimately finds its way into real kind of use cases or into the marketplace. One could see that you might want to use this. If there was an application, let's say an online court, and you have a robo judge, and that robo judge would then try to have the same expressions as the ones that you observed, and would very much act like Judge Judy, who I think is a real judge, but obviously optimized for the television experience. And you would presumably also, as the previous speaker I think validly mentioned, you want to correlate the content of the proceedings and with the actual performance of the proceedings, so that that's at least congruent. But anyway, so I don't want to. So there's a lot of other questions that folks have. So, and we should really try to race through them quickly, because we want to leave some time for our next speaker too.
Can I ask?
Yeah, I just let me. Okay, so who's next? Go ahead. You speak up.
Can
we
I
have
ask?
some in the
Okay.
chat too, and I want to get to those too. But please go ahead.
Okay, I needed to ask, where do you plan on taking this in the long term? Is it going to be like an actual product, or are you creating robot judges? Like, where is it going long term?
Good question. Right now is a conceptual design piece, and we're exploring future. We're creating this to see how people react. This is kind of reaction that we want to generate. People say, no, this is not authentic. We appreciate that, because from a design point of view, this is what we want to create, authentic reactions, to mimic what the presentation said. So yeah, eventually, definitely. I mean, if this concept gets more robust, then of course it can be a commercial or even publicly available for courts around the world that want to use it. I don't know. It's open yet.
Nora is asking, thanks for your presentation. Are there any plans to make the data you collected and labeled publicly available?
That would be great. I'm a big fan of open source, open access data. I think is data being generated from the public should stay public. That's kind of from my perspective. However, we only, for example, this just to show you something. we only have now approval to analyze Chilean videos. That's why we're also working on some kind of pilot project. Maybe Susan can tell you more about that, to see how could we eventually get data from the US, right? Because we need approval to be able to analyze those video recordings.
Got it.
But I think that's the kind of a pretty strong principle in my design, I would say.
Okay, so Nonopa is saying, was the research data centered around the US only? So you already answered that just now. And then Lance is saying this research seems in the realm of legal sentimentality analysis, LSA, which is increasingly being powered and oftentimes is paired with legal opinion mining that analyzes the words spoken during a court case using NLP. Have you considered analyzing both the visual elements of the attorneys, judges, and the actual words being spoken? I think you talked about that too a little bit. Did you want to add anything?
Yeah, no, I mean, yes.
That? I think you answered that already before.
I think it's one part that is in the bucket. Yeah.
Okay, then Eduardo is saying Victor Quintanilla has also done research on the social construction of self-represented, I guess, self-represented litigants, I suppose. He sends you a reference for that. Scott's asking, I'm wondering if you're addressing and asking interpellation questions in ways regarding AI and performativity. I'm not sure I understand that, but.
Within the court, so the interaction between judge and or between lawyers and witnesses, you mean, Scott?
Scott, are you there? Okay, so it's kind of fell off. Maybe we'll come back to that later. And we really have to, let me see. And then there's other folks with more commentary. So I think we should probably move on to the next speaker. But if you could put your email address into the chat so that people can reach out to you directly with additional questions. It seems like folks have more questions for you directly. And I wish we could spend more time discussing this. It's a really fascinating project and very cool. I'm really glad you came in to share it with our group. And then, you know, folks can reach out directly to you. So please type in your email address into the chat.
Sure. Yep.
And then we'll turn it over to Stefania. Thank you so much. Big round of applause.
Thank you very much,
Joaquin. And where are you? Are you in Munich now? Or where are you? Somewhere in Germany?
No, we're in Potsdam. I'm in Potsdam, and the Hasso-Plattner Institute is located in Potsdam, right out of Berlin.
Got it. Okay. Good. Well, thank you so much again. And Nonopa is raising her hand.
No, that was before.
Oh, okay. Sorry. Okay. This is from before. Okay. Thank you. Okay. Good. All right. Thanks again, Joaquin. Great to have you. Please keep us posted. And then let's turn it over to Stefania. Are you there?
Hi, I'm here. Hello from Tokyo.
There you are. Okay, good to see you. Thanks for joining us. What time is it in Tokyo now?
It's 7:04 a.m. Friday.
Okay, so thanks for getting up early for us. We really appreciate it. And
my pleasure.
This is a week that we haven't heard very much about legal tech and legal innovation in Japan. Mm-hmm. And we heard a little bit about innovations coming out of Latin America. And you're an expert on both. So it's great to have you, and really excited to learn from you. So over to you.
Hi, thanks. Let me just share my screen real quickly. Can you see my screen now?
Yes.
Perfect. So thank you so much, Roland, Susan, for extending this invitation. I'm really glad to be here. I've been attending 2 sessions in the past, so really excited to be in front of so many interesting people with the same interest in legal tech. My name is Stephanie Santana. I'm the practice development lead at Legal Force here in Japan, in Tokyo. And I'm also the co-founder of ALIL in Latin America, which is the first regional legal tech association in Latin America. This is going to be this is very ambitious to try to cover both markets in a single 50-minute session. So please, by any means, if some point you would like to know more points, you can reach out to me by LinkedIn. It's my name, Stephanie Santana, and you can find me there. So let's start. This is the agenda for today. As I said, it's ambitious. I'm gonna start talking about the very beginnings of Japan legal tech, market size, legal tech map. Then I'm gonna use Legal Force, the company where I work, to show you how fast things are going here. Then I'm gonna, as a point of comparison for you living in the US, I'm gonna compare the adoption level in Japan versus the US. Then I'm gonna talk about the recent developments. And for Latin America, it's gonna be quite short. And then again, please, by any means, feel free to contact me to discuss more. So I'm gonna show you in a nutshell what's going on. And then I'm gonna make an introduction of ALIL, the association, and then a few final remarks. So let's begin with Japan. The first legal tech efforts can be traced back to the 90s, actually, where the Japanese Patent Office was the first in the world to accept online applications. But then the rest of the 90s remained calm. And in the 2000s, we start seeing things like marketplaces for lawyers, which is not really tech, but can be considered because it was online. Then a few e-discovery tools that have become massive, and even Frontio, it's already in the US. Maybe some of you know about it. And although Japan is a civilian jurisdiction, so we don't have e-discovery as a procedural rule, but they use it as forensics. They call it forensic legal forensics. So for instance, to do compliance work or to do to manage cases of misconduct in companies, and they have to review documents. That's what they use it for. And then in 2015, we really see that legal tech starts becoming, really people start hearing the word and knowing what it is. And then we start seeing like a really steep curve in the number of players that join the market. So that's for the brief overview. At the moment, the market size is growing steadily year by year. So back in 2018, it was 219 million US dollars, the value based on the business sales volume. But the Yano Research Institute, it's forecasting that it's going to have a steady growth of 9.8% per year. So by the year 2023, it should reach $339 million. And this is quite remarkable because Japan is stagnant. It has a steady, it has basically no growth because the population is actually shrinking. So having this growth is significant, and especially it's one of the few markets actually that it's predicted to grow up to. Okay, so this is a chaos map. This was developed by one of the main players in legal tech here, the CloudSign. And basically how to read this map, it's that they have divided into several categories of tech. And then on the left, you can see that it has divided by the kind of customers or users. So for individuals, for companies, or for legal professionals. So categories 1 and 2 relate to tech contract or technology for contracts. And that would be the main leader, let's say, the main category that is leading the change and the growth here in Japan. Then, of course, e-signatures that can be also related to contracts. Actually, you can find Legal Force, my company, right there in the contracts, but we also have agreements. So there are partnerships between these different actors. So this map would look different if we were to show like all the kinds of agreements that have been built among them. But this is a a good overview for you. Then category 3 is signatures. Category 4 are tools that assist with applications for government transactions, including visas. That's a big one because obtaining a visa in Japan is extremely tedious. So that has found a niche here. Then we have the legal research tools. And this one, we still consider it, I think, a legal tech. I know in the US it has been gone forever, but here in Japan, it's amazing how much like they rely on books. Like my company has an English side and a Japanese side, and the lawyers working doing the research for the Japanese side have like 2 stacks of books. So having this change towards legal research tools is quite significant here still. Then, as I mentioned, due diligence tools. And lastly, dispute resolution and litigation, which is still nascent. I'll say there are not too many players in that area. Let's move on to see an example, really. So LegalForce is the company where I work. It's the first cloud-based contract review powered by artificial intelligence. So as you can see, in April 2015, we were founded. Then in 2019, we first launched our Japanese product, the contract review. Then I joined in May, actually, 2019, and work for the release of the English product in November 2019. Then last February this year, we raised $10 million in Series Bs. In last August, we already released a second product. And this is more or less the pattern that most of legal tech companies working in the contract tech sphere are following. It's going really, really fast for everybody. So I know all the things that I'm talking right now are all numbers and things. So just to give you a visual idea of how the market is still lagging behind compared to the US, we can see here the percentage of tech adoption here in Japan versus the US in terms of legal departments. So while the US has already over 30% of companies are familiar or using legal tech, here in Japan it's only 17%. So pretty much a blue ocean still. And in terms of legal firms, it's even less than that. Like it's not very used, but that is going to change. These are some of the recent developments here in Japan. So in October 2019, a top Japanese firm, Nagashima Ono, entered an alliance with a startup called NLP, and they invested $7 million. Then last November, the biggest Japanese law firm invested in Rain & Court as an effort to become, to go forward. They really want to follow. I think here the Baker McKenzie example is what they are aspiring to. So in that effort, they invested in Rain & Courts. And we can also see that more and more foreign startups are joining here the pool of legal tech providers. So Luminance just last month expanded into Japan and Korea. And of course, these are really big efforts because Japanese is quite a difficult language. So I think that's one of the main points why this is not, or foreign legal providers are not coming faster here, because Japanese is extremely difficult language for a non-Japanese to grasp and to understand, especially in legal terms. All right, so now let's move to Latin America. This is a map of the countries, not all of them, but the countries where at least we can see a little bit of development of legal tech. As you can see, the big winners, the big winner is Brazil, but it's a Portuguese speaking country. So it's not really, cannot compare the technology being used there, cannot really be used in the rest of Latin America that is Spanish speaking. But anyways, they are really leading the way on legal tech. Then we have Colombia, then we have Peru, and then we have Chile. So in Brazil, we have around 162 projects that were mapped as of this year. In Colombia, about 100. And in Peru and Chile, about 30 or more. In the most popular category of legal tech, the top one is legal research and firm management software. Then top two is the online legal research and legal counseling. 3, legal marketplaces. 4th, contract tech. And 3, online claims and dispute resolution. And also something to notice is that most of the development is in South America as compared to Mexico or Central America. And I also believe I don't have data for this, but from my interactions with many players in Latin America, legal design is huge. I haven't heard so much legal design here in Japan as I'm hearing in Latin America, especially efforts to make regulations more user-friendly, if you want, and really simplify contracts. There is a big vague of these legal designs efforts that I've seen in Latin America. Then ALIL. So ALIL is the first regional association for legal innovation and technology in Latin America. So it was founded by 7 other professionals and myself back in September of this year. And we represent 6 countries in the region. And quickly, as you can see, in less than half a year, we already have 100 networking members, 100 registered members, and we work around 3 lines of action: education, acceleration, and communications. So most of our members speak English. I mean, our networking members and registered members. And in any case, we really want to know more about what's going on in other places. So I invite you to follow this Q&A little sign and join us in our LinkedIn page. We will be glad to have so many experts and so many people that are eager to learn from you. And finally, for my conclusions, so I think both markets, Japan and Latin America, have a deep interest in legal tech and a growing interest. Contract tech is predominant in Japan. I think it's because they're a little bit more mature, or much more mature than Latin America. And legal research tools are predominant in Latin America. I consider both are still blue oceans if you really want to try, especially in Latin America. Of course, contract tech that is already predominant in other parts of the world is still not in Latin America. So that is a big blue ocean there. And in Japan, as I mentioned, for things like dispute resolution and other types of tech that are not contract related, this is also Japan is also a blue ocean. So this concludes this very brief overview of both regions. So Roland, back to you.
All right, that is very interesting. And let me ask you, let's see, what is sort of the position of the bar associations in Japan with regard to these legal innovations? Are there similar kind of obstacles that exist in terms of some of those rules around unauthorized practice of law or fee splitting? Is there a similar issues in Japan, and what's the status quo?
So it's not as restricted as the US. I've been following what's happening in the US that is opening up. Here, fee splitting is not a big issue, but it is an issue that non-lawyers are providing legal services. That's very similar to the US. However, you can contour that pretty easily if you don't give legal advice per se. But I would say there is not, the public sector is not really involved yet, or there is not a true effort to try to incorporate or to promote these kind of things. And I think in that sense, in the US is very different, because I know, for example, Utah, Florida, they're trying to promote using these, things that they can move faster, digitalization of some processes. Here in Japan, we don't see that kind of support.
Okay. All right. Thomas is asking about what is Japanese law like? Is it case law, or statutory law, or just be polite?
It's civil law. No, it's civil law. So it's not case law at all. It's civil. We have a civil code, so it's not case law.
Okay. And what did you use to make your slides? Nopa is asking.
Sorry, why did you use to make?
No, what did you use to make your slides? And it seems to like slides in particular.
Okay. PowerPoint.
Okay. All right. Well,
PowerPoint in my hands.
Yeah. And what's it? So what took you into the contract? So your company is one of the contract automation players, or contract analytics players, or
contract review.
Contract review. But you come to this as a technologist or as a lawyer yourself originally?
First as a lawyer when I joined, and as I grew in the company, I've become like coding, and I'm involved in all the tech aspects as well.
And are your customers, are they mostly in-house departments, or are they also law firms?
Yeah, we are mostly, as I show you in the slides, our product is mostly for law departments, legal departments, which are quite different from the US, because here legal departments are not, they don't have lawyers, because the pass rate here for the bar is 2%. Mm-hmm. So it's not easy to be a lawyer.
Mm-hmm. And so how come you have this kind of dual focus on Japan and Latin America? So you're in Japan, but you started an association for Latin America. It's an interesting kind of combination. Can you share a little bit?
Sure. So yeah, sure. So I am from Peru. Originally, I was born and raised there, moved to Canada to study law. And as I was in Canada, some of my contacts here started Legal Force. And when I heard they were expanding their practice into English, then I took the opportunity to move here. And yeah, I was in charge of the release of our first English product.
Yeah,
that's okay. How I found her. Yeah.
But so you're now in Canada, or you're now in Canada?
No, I'm in Tokyo.
Oh, in Tokyo.
I'm in Tokyo.
Oh, you
yes.
Okay? Sorry, you went to Tokyo to start the English
I moved here.
Product of the company. Oh, very interesting. All right, folks.
Santana, hi.
Yes, hi.
A quick question. Is there a standard by which the Japanese contracts are drafted, or is there like some format, some guidelines on templates? I mean, is it free text completely? Whoever.
No. Mm-hmm. Thank you for the question. Actually, it has been fascinating for me to work here, because like as in Canada, contracts can be this size. In Japan, sometimes they don't even have a contract. People trust each other so much that even like in between big manufacturers, Toyota and Mitsubishi, they won't have a contract together. They would just have an oral contract for millions and millions of dollars worth of transactions. But so in that sense, the contracts are much smaller. If there is a contract, contracts are maximum 20 pages. You never get to see a contract that it's over 20, 25 pages. They have certain rules that they keep. I'm not exactly sure, because I don't read Japanese, so I'm not exactly sure the structure. But when we build this product, we create a policy of rules for each. So we create one policy per contract, and in both Japanese and English. So there is a structure, but it's much simple than a contract in the US or Canada.
Can I ask you, so this is a company that started in Japan, and you presumably created an English version because you want to expand the product beyond Japan. And what is sort of this is a pretty crowded area, contract analytics, contract review. Which one of the players in that industry do you feel is the most kind of comparable to you, or who's your kind of the company that you feel the most competitive with?
Yeah, there are a few. We were the first though, but there are a few that entered the market. There's Hubble, there is AI Con, but our product has a very good. So first of all, I just want to clarify, we are not planning to expand to the US. Our product is just for Japanese use. In English, contract review for English is pretty relevant because here people are not really bilingual. However, they have to deal with when they do transactions with foreign companies, they get some English contracts, and they get like a 40-page contract, and they're like, what do I do? And then they have to hire external counsel, and it becomes expensive. But our product allows them to have a look, because our product basically checks for risks. That's our motto is we control all risks. So when you use our product, we flag risks according to which side of the transaction you are. And then you can have someone with some knowledge of English to understand the contract, at least the main points, and see if whether or not they can accept this contract or they have to negotiate through a foreign lawyer. So that's the value of our product, of our English product here. Then the main competitors, yes, Hubble, AI Con, some that want to enter the market. With Luminance is entering the market as well, so that might be a competitor for sure. They have a good track record, but we are the first, and we have the biggest customers by thus far. Like we don't really compete with, like it's not comparable yet.
Right. Thomas is asking, what would constitute a risk that your software kind of highlights? What are some examples of that?
IP, especially IP, how much IP you're sharing. Other things can be, I'm actually working on a consulting contract. So some of the risks can be that the consultant can be treated as an employee as opposed to an independent contractor. So those kinds of general risks. Of course, we don't create a very specific contract for each case because that will be impossible, but we try to frame all general risks in our product.
Okay. Okay, and how does your system pull in the contract? Is it
yeah, our inspection system,
or is it an expert system? How does that work?
Oh, well, it's an inspection system. That's our key competitive advantage, I think. We have a really solid inspection system. So yes, we really use natural language to try to, we are feeding right now, every month we feed about 1,000 or more contracts to our system to get used to the language. So we really identify by clauses. So we will feed our machine learning with clauses examples. So the machine will pick up, if you want, a whole clause or a whole article, depending on how it's framed. Yeah, it's not by word, not word by word. It's really by clause.
Interesting. Okay. Well, great. And what do you see as the sort of the biggest obstacles in to more adoption of legal tech, either in Latin America or in Japan?
I think culture. Culture is one of the biggest things, because here in Japan, although as I mentioned, like our target clients are not lawyers because they work in legal departments. And here in Japan, legal departments are run by one lawyer, and then the rest are non-lawyers. They are contract specialists, or they have some, or paralegals. Because as I repeat, only 2%, the bar pass rate is 2%. So there are not too many lawyers. The market is not flooded with lawyers here. It's the opposite, actually. So our product is used by really people that are not lawyers. So this has made it easier. Like we don't have an ego conflict, It's not like the machine is replacing the lawyer. But I think as I show in the developments, even lawyers are trying to adopt. But I think also there is a misunderstanding of what legal tech is. I participated in a conference last September, and I talk about legal operations and how it is important to adopt tech. And people just didn't seem to grasp that tech and culture like are together. Like you need to change your mind to adopt tech. Like that concept is still like, for them, tech is tech and it's not a change of mind. So I see that in Japan. And in Latin America, I just think it's a lack of resources. I think in Latin America, that's a big issue too. Here in Japan, we don't have that as much. And so in Latin America, it will be impossible to pay for a small firm or a single practitioner to pay all these expensive tools.
Mm-hmm.
But I think, yes, culture will be the common denominator in both.
Yeah, it is probably everywhere, really. But good. So we are already a little bit over our time. Stefania, it's been great to learn about your business, but also more broadly about the Japanese legal tech market and the Latin American. So really appreciate you sharing your expertise with us. This is if you could maybe put in your email address into the chat so folks can reach out to you directly if they have more questions. And to everyone, to all the speakers, thank you so much for joining us today throughout the year. Thank you everyone else for participating and making these sessions really interesting and high level. And this is really a great group, and really appreciate everything you bring to our center and to these group meetings. And I wish you all a wonderful holiday season. And I look forward to seeing you again in 2021, which I hope will be a much better year for the world and us all. And I look forward to being in touch. Thank you all, and see you on the other side. All right, bye bye.